So, placed by a mercantile agent as according to section 178 of the Act, where a mercantile agent is with the consent of the owner in possession of goods or the documents of title to goods, any pledge made by him when acting in the ordinary course of business of mercantile agent shall be as valid as if were expressly authorized by the owner of the goods to make the same, provided that the pawnee acts in good faith and has not at the time of the pledge notice that the pawner has not authority to pledge. So the very explanation in relating to section 178 of the Contract Act is in this section. The expression mercantile agent and documents of title shall have the meaning assigned to them in the Indian Sale of Goods Act 1930. So, as under section 178 emphasizes that a mercantile agent shall be in the possession of documents of title with the consent of the true owner thereof, if he is in such possession and place the goods by transferring the documents of title to the said goods by fiction, he is deemed to have expressly been authorized by the owner of the goods to make the same. And as we found in the leading case, Morbi Mercantile Bank Limited, Union of India in 1965, the Supreme Court expressed the condition of consent set to the fiction of authorization indicate that is doing what the owner could have done. So, all the following conditions must be fulfilled before a pledge made by a mercantile agent can be binding on the true owner of the goods pledged. So, one is that the pledge must be made by a mercantile agent. A pledge by a mere servant or wife is not valid, even though in possession of goods with the consent of the owner. The general rule is expressed by the maxim nemo that quod non habet, and that is no one can convey a better title than what he has. To this maxim, to facilitate mercantile transaction, the Indian law has grafted some exceptions in favor of bona fide pledge by transfer of documents of the title from persons, whether owner of goods or their mercantile agents, who do not possess the full bundle of rights ownership at the time the pledges are made. And secondly, the mercantile agent must be in possession of the goods or documents of title to goods with the consent of the true owner. Thus, the goods obtained by theft cannot be the subject of a valid place. And thirdly, the place must be made by the mercantile agent while acting in the ordinary course of business of a mercantile agent. And fourthly, the pony must act in good faith and without notice that the pawnee has no authority to place. So the words in good faith imply that a place is not valid if the pony is aware that mercantile agent making the place has no authority to make the same or was acting mollified against the owner. So, in the very leading case, Moody and Pulmeli in 1917, a place it was held by the court by a mercantile agent made after the revocation of his authority is valid provided the pledgee has not at the time of the pledge notice of such revocation. So the principal can avoid the pledge if he establishes that the pledgee had notice of revocation of authority of the agent at the time of the pledge. And now we'll discuss the very difference between pledge and mortgage. And as usual, decided by the leading case Damodar versus Atmaram by the Bombay High Court, also Raghu Muthaya versus Sabina Sadhana in 1919 by the Madras High Court. So, in a place, the general property or ownership continues in pleasure. A pledgee has a special right to retain and files a suit and no shall as under section 176 of the act. In case of a mortgage, the legal title passes to the mortgagee subject to the right of redemption which vests in the mortgagor, as it was decided by Bombay High Court in the leading case Damodar versus Atmaram. And as mortgagee has a right of foreclosure, while a pledgee has no such right of foreclosure, as it was decided by the Madras High Court in Raghumathaya versus Savina Sadhana in 1919. So a place cannot be effected except by delivery of possession, while a mortgage can be effected without possession. So these are the basic differences between a place and mortgage, as it was decided by their lordship in the very decisions regarding the leading case Damodar versus Atmaram by the Bombay High Court and Raghu Mathaya versus Savina Sadhana in 1990 by the Madras High Court. So, all the important questions relating to contract of Bailment, as already we have discussed all the 9 important questions with the respective answers and illustrations and all important leading cases. So in our next upcoming video, we would like to discuss the very provision as per the Contract Act regarding the contract of agent